Well, tonight we have news in the fastest moving case against Donald Trump in Georgia and in the slowest moving federal case against Donald Trump in Florida, where Donald Trump's favorite federal judge, who he appointed, took a full month to issue a standard order that could have taken another judge less than a day, prompting Andrew Weissmann today to tweet, "Unbelievable how long this has taken." We begin tonight with the high-speed action today in Georgia. Last night, Donald Trump formally waived his right to a speedy trial. And then this morning, a lot more waivers of speedy trials. This morning, the action began at 10:13 a.m. with Mark Meadows formally waiving his right to a speedy trial. And then the judges and litigants got really busy. 10:20 a.m., federal judge Steve C. Jones denies Mark Meadows' request for an emergency stay. 11:29 a.m., David Schaefer waives the right to a speedy trial. 11:43 a.m., Jenna Ellis waives the right to a speedy trial. 11:45 a.m., District Attorney Willis files a reply to the 11th Circuit Court of Appeals opposing an emergency stay for Mark Meadows. 12:18 p.m., Sean Still waives the right to a speedy trial. 1:15 p.m., Stephen Lee waives the right to a speedy trial. 2 p.m., Harrison Floyd waives the right to a speedy trial. 2:26 p.m., Robert Shealy waives the right to a speedy trial. 2:40 p.m., the 11th Circuit Court of Appeals grants Mark Meadows an expedited appeal schedule. 4:23 p.m., Sidney Powell files a motion to dismiss the indictment. 4:36 p.m., Scott Hall waives the right to a speedy trial. 4:50 p.m., District Attorney Willis files a brief answering the 11th Circuit's question about removal of a case applying to former government officials. 5 p.m., Mark Meadows' team files a brief answering the 11th Circuit's question about removal applying to former government officials. 5:30 p.m., Mark Meadows' lawyer renews the request for an emergency stay. 5:40 p.m., the 11th Circuit schedules oral arguments on the Meadows motion for an emergency stay for Friday at 10:15 a.m. District Attorney Willis agreed with Mark Meadows' request for an expedited appeal, since District Attorney Willis also wants the case to move as quickly as possible. The 11th Circuit's schedule issued today for the expedited appeal is even faster than what District Attorney Willis specifically requested. The appeals court said that Mark Meadows' appeals brief is due Monday, next Monday, September 18th, with District Attorney Willis's response brief due exactly 1 week after that, with Mark Meadows then getting 3 more days to reply to the District Attorney's brief. And with that schedule, the Mark Meadows appeal will surely be decided in the month of October, possibly early October. The question posed by the 11th Circuit Court of Appeals surprised everyone yesterday when they asked the litigants to address the question, does the statute permit former federal officers to remove state actions to federal court, or does it permit only current federal officers to remove? In all of the discussions we had on this program prior to the appeals court asking that question, none of us considered that possibility. I think it's fair to say that virtually everyone commenting on the case on television and elsewhere presumed that the federal law that allows federal officials to move criminal cases against them from state court to federal court applies to current federal officials and former federal officials. No one questioned that until the appeals court did. Mark Meadows' attorneys filed a brief basically saying it just makes sense that it should apply to former government officials like Mark Meadows, which was a widespread belief about this. But District Attorney Fani Willis's brief today was, for me, surprisingly convincing that the law does not apply to former federal officials. District Attorney Willis says only current federal officers may remove state actions to federal court. The law in question grants the right to move cases from state to federal court to, quote, any officer of the United States. District Attorney Willis's brief points out that another section of the same law specifies that that section applies to anyone, quote, who is or at the time the alleged action accrued was a civil officer of the United States. District Attorney Willis's point there is that federal law does know how to specify that it applies to former government officials. And District Attorney Willis cites a finding in another case saying where Congress includes particular language in one section of a statute, but omits it in another section of the same act, it is generally presumed that Congress acts intentionally and purposely in the disparate inclusion or exclusion. Where Congress knows how to say something but chooses not to, its silence is controlling. District Attorney Willis's brief says that the reason for the federal law allowing federal officials to move their cases to federal court, quote, is to prevent state interference with the operations of the federal government. A state prosecution of a former federal officer can hardly interfere with such operations when that former federal officer no longer has any role in the operations of the federal government. There is no longer a federal interest to protect, and this court must presume that Congress recognized that fact.